It was supposed to be a routine hearing, just another day in court. A basic DUI, file it, fine it, move on. But the moment Christopher Whitman walked through that courtroom door, the energy changed. You couldn't miss it. Not because of him, though yes, he had that polished, private school proud of it look, but because of who walked in with him. 5 attorneys. 5. And not some dusty public defenders or small-town legal warriors.
If you enjoyed this breakdown, don't forget to like, subscribe, and drop a comment. Your feedback helps shape what we cover next, and you being here keeps the conversation going. Thanks for watching. See you in the next one.
No, this was a high-octane legal dream team from Whitman. Sterling and Associates, a corporate law powerhouse with a glass tower office and $1 million retainer price tag. These were the lawyers who normally argued over mergers and antitrust cases, not misdemeanor DUIs. It was like bringing a nuclear warhead to a Nerf gun fight. And the judge presiding that day? None other than Judge Frank Caprio. You've seen the videos. The grandfatherly tone, the empathy, the measured logic. He's the kind of judge who might give you a second chance if you deserve it. But he's also the guy who sees right through performative nonsense. So when this mini army walked in behind a guy who'd blown a 0.12 after a Friday night out, Caprio clocked it immediately. Not the suits, not the credentials. He clocked the overkill. Why does this kid have 5 attorneys? Why does a routine DUI come with a brief thicker than most murder trials? And then he flipped through the documents. The 50-page defense brief, complete with appendices, citations, expert statements. The estimated cost of preparation? $64,000. That's when the judge's expression shifted. He wasn't mad. He wasn't impressed. He was suspicious. And he had every reason to be. See, what Judge Caprio noticed, what most people wouldn't even think to check, was where the money trail ended. And it didn't end with Christopher. It didn't end with the Whitman family. It didn't even end with someone quietly covering the bill out of pocket. No, the invoice had been routed through the firm's internal billing system, coded as research and litigation strategy, paid for in full by client retainers. Christopher Whitman's legal defense was funded by the firm's clients. The jaw doesn't drop immediately. It kind of hangs, like your brain needs a second to process the audacity. Because this isn't just sloppy accounting. It's not a one-off mistake. It's theft. A white-collar, Armani-suited, polished and printed act of fraud. And it's also one of the dumbest, boldest ethics violations you'll ever see. Judge Caprio asks the question, did the clients authorize this? No one answers. Then he asks the second one, are these attorneys aware that using client funds for unrelated personal matters violates multiple rules of professional conduct? You could hear the sweat forming. It's courtroom silence, the kind that's louder than a gavel drop. What follows next is nothing short of surgical. Caprio doesn't scold. He doesn't grandstand. He simply adjourns a hearing, walks back into chambers, and places a single phone call to the Rhode Island Bar Association's Office of Professional Conduct. And in that moment, the scales tip. What started as a privileged kid walking into court expecting his name to do the heavy lifting just detonated the professional reputation of one of the state's most powerful firms. The investigation moved quickly. Bar investigators requested billing records, internal emails, call logs. And what they found wasn't an accident. It was policy. Multiple partners had signed off on it. Associates had raised concerns and were told in writing that this is handled at the top. One poor junior lawyer even left a paper trail of Slack messages expressing concern about client funds being used for non-related criminal defense. The response? Don't worry about it. This is family business. And that phrase, family business, ended up being the smoking gun, because what they were doing wasn't just unethical. It was deliberate. They were exploiting client trust to shield the managing partner's son from facing legal consequences. And they thought they'd never get caught. Turns out, all it took was one judge willing to read the fine print. The fallout? Nuclear. 4 attorneys suspended. 2 partners hit with official reprimands. 1 disbarred. And the firm's founder, Gregory Sterling, stepped down in disgrace. No farewell tour. No closing speech. Just a terse email to staff and a press release filled with legalese that basically boiled down to, "We regret being caught." And Christopher? He pled guilty, got a jail sentence, license revoked. But the real punishment? The fact that every article about this story had his name in the headline. The trust fund can pay for private security, but it can't scrub Google's search results. Still, the real tragedy here wasn't Christopher's arrest. It was a betrayal. Because this wasn't some sketchy back-alley operation. This was a firm that served Fortune 500 clients, handled billion-dollar accounts, represented institutions that depend on absolute trust. And that trust was shattered in a single courtroom with a single unethical decision. All because they thought no one would notice. But Judge Caprio noticed. And that, my friends, is the lesson. For all the power, all the money, all the prestige these institutions flaunt, they are one ethical breach away from total collapse. No amount of spin can fix it. No crisis comms firm can sweep it under the rug. When you misuse your client's money to defend your own family member, and you do it without remorse, you don't just cross a line. You set it on fire and then hand out marshmallows. Law schools now teach this case as a gold standard in ethical failure. It's studied, picked apart. Future lawyers read it and realize, oh, this is how fast a career, a firm, a legacy can disappear when ego gets in the driver's seat. So, next time someone tells you the system is rigged in favor of the powerful, remind them, not when the right judge is watching. Now I've got to know, what's your take? Was this a one-time scandal, or just the tip of the legal iceberg? Do you think justice was served, or did Christopher get off easy? Let me know in the comments. I want to hear your verdict. And if you're into stories where the elite eat themselves, where the courtroom delivers actual accountability, and where the most powerful names crash harder than anyone else, go ahead and like this video, share it with your favorite group chat, and hit subscribe. Because if this case taught us anything, it's that no name, no legacy, and no amount of expensive legal help can outrun the truth. Let's go deeper. Because while the headlines may have faded, and the legal brief is collecting dust in some archive folder marked internal use only, the ripples of the scandal haven't stopped. They're still moving, quietly, through boardrooms, law schools, courtrooms, and whispers over overpriced lunches between people who still have their jobs because they didn't get caught. But let's back up, because the real punchline to this whole mess is that the downfall didn't start in the courtroom. It started in the conference rooms. The long, glass wall ones where people in custom suits say things like optics and strategic exposure. The rooms where every ethical red flag can be waved away with one simple phrase. Well, it's just this once. You can almost picture it, right? The managing partner, Christopher's father, sitting at the head of the table, smoothing out his tie, explaining to his trusted lieutenants why this little internal favor was justified. It's family, he probably said. This firm was built on loyalty. What he meant was, don't ask questions. Just protect my kid. And because the culture was already rotten, because this was a firm where hierarchy trumped integrity, they listened. They said yes. And then they billed $64,000 worth of research, drafting, and prep hours to clients who were never informed, never asked, never even considered in the decision. And that's where it all falls apart. Because these weren't faceless clients. They were real companies, real people. Businesses trusting that their six-figure retainers were going toward protecting them, not bailing out a trust fund disaster who couldn't say no to a few too many cocktails behind the wheel. And here's the part that makes your blood pressure spike. They almost got away with it. If Christopher had walked into that courtroom with one attorney, just one, they would have been fine. No judge would have blinked. The brief would have been quietly overkill, but not suspicious. And even if someone did raise an eyebrow, there wouldn't have been enough pressure to pop the balloon. But ego ruined them. Christopher had to walk in with the full entourage. He had to turn a minor criminal case into a stage play. He had to make a spectacle of just how above the system he thought he was. And when you step into Judge Caprio's courtroom with that kind of swagger, oh, you'd better be clean. Because Caprio doesn't miss. He's not flashy. He's not theatrical, but he reads between the lines like it's his second language. One look at the brief, one glance at the billing structure, and he knew this wasn't a defense. This was a scheme. It's funny, isn't it? All the degrees, all the internships, all the late nights chasing partner titles. And as a judge with a question and a phone call who brings a whole thing down, that's justice. Quiet, sharp, and completely unavoidable once it finds you. But the most haunting part? This wasn't some one-in-a-million mistake. This was standard operating procedure. Just exposed. After the story broke, former employees started coming forward. Anonymous quotes, leaked memos, people who'd worked for the firm years before, saying this wasn't the first time the Whitman name had pulled rank, that this kind of internal favor work was whispered about in elevators. That one associate had even drafted paperwork for a Whitman Cousins real estate dispute, billed under consulting hours for a tech client that had no idea it was paying for someone's personal property drama. And suddenly, this isn't just about a DUI anymore. It's about a culture that believed reputation equals immunity, a culture where power meant bending the rules just slightly until they no longer resembled rules at all. And while the firm scrambled to spin it, isolated incident, temporary lapse in judgment, we've launched a full internal review. The rest of the legal community quietly turned its back. Because even in a world as cynical as corporate law, there are lines. And this one wasn't blurry. This one was drawn in bold ink, underlined twice. Client money belongs to the client. Period. But let's not give the firm all the attention. Let's revisit Christopher. Because while the firm burned, Christopher didn't exactly go underground. No, he did what any post-scandal golden boy does. He pivoted, rebranded, tried to reinvent himself as a changed man. New social media accounts, deleted old photos. One particularly unhinged LinkedIn update titled, "Why Failure is the Greatest Teacher." It was heavy on vague self-reflection and light on any actual mention of what he did. One line stood out, though. In life, it's not about how you fall. It's about how you rise. Sir, you didn't fall. You were pushed off a pedestal you had no business standing on and landed on a safety net of generational wealth and legal privilege. The rest of us don't get to rise after using other people's money to cover up our messes. You don't get to moralize your way out of a courtroom scandal. Not when your lawyers are still on suspension. Not when your name still sends interns into a cold sweat. And not when every law professor from Yale to UCLA is using your case as an example of what not to do. Speaking of law schools, yes, the Whitman case is officially part of the curriculum now. It's been dissected in ethics classes, cited in debates, and analyzed in papers with titles like Client Trust and the Crisis of Corporate Loyalty. Students act out mock hearings. Professors draw diagrams of the billing chain. One school even handed out red pens and asked the class to mark every ethical violation in the 50-page brief. They ran out of ink. And here's where it gets almost poetic. Gregory Sterling, the firm's co-founder and one of the orchestrators of this entire mess, now teaches part-time at a mid-tier law school. Not civil litigation, not firm management, legal ethics. Let that sink in. The same man who watched client money disappear into his son's defense now lectures wide-eyed law students on moral clarity in high-stakes practice. And the saddest part? He probably thinks he's being redemptive, that this is his legacy arc. But everyone else sees it for what it is, a cautionary footnote in a cautionary career. The name Whitman, once synonymous with power, now lives on in footnotes and firm horror stories. And honestly, that's justice too. Because in the end, no amount of crisis PR, courtroom polish, or rebranding campaigns can wash off what this case revealed. Not just one man's corruption, but the arrogance of an entire system that thought it could get away with it. And it almost did. Almost. And look, if you've made it this far, you know this wasn't just some legal slip-up. This was a slow-motion implosion. A prestige law firm built like a fortress undone by one entitled decision, one phone call, and a judge who refused to play along. But let's really sit with what happened here. Because there's something uniquely twisted about a system so used to getting away with things. It doesn't even realize it's breaking the rules anymore. At Whitman, Sterling and Associates, this wasn't a heist. It wasn't some covert cloak and dagger operation. It was business as usual. Someone in that firm literally typed in a billing code that rerouted client funds to defend the boss's son, and nobody blinked. That's what makes this story so maddening. Not just a betrayal, but the boredom behind it. Like, this wasn't a desperate act. It wasn't a firm circling the drain, scraping together a last-ditch lifeline. This was a top-tier operation. They had options. They could have brought in a private criminal defense attorney, paid out of pocket, kept the whole thing airtight. It would have cost them a fraction of what they ultimately lost. But they didn't, because somewhere along the way, they stopped seeing the line. And Judge Caprio, he drew it back in red sharper. Now, what's truly fascinating is how everyone around the firm responded once the truth got out. There was a partner who'd been with the firm for 15 years, never so much as a parking ticket to his name. He resigned within 24 hours of the news breaking, not because he was involved, but because he knew what this meant. He knew no amount of press releases or internal reviews could ever restore the trust. He packed his desk, handed in his card, and walked out before the firm could slap his name on the damage. Meanwhile, the firm tried everything to control the narrative. They even hired a crisis comms agency, one of those sleek ones that brags about reputation resilience and narrative engineering. Their job? To make the public forget, to drown the scandal in a sea of vague, forward-looking optimism. There was a glossy website update, full of buzzwords like transparency, rebuilding, shared values. They even created a section called Looking Ahead, which read like it was written by a corporate AI trying to apologize without admitting guilt. Spoiler alert, it didn't work. Because every time someone Googled the firm's name, the top results were still the same. CEO's son uses client funds for DUI defense. Firm founder resigns amid ethics scandal. Judge Caprio uncovers billing fraud in courtroom bombshell. That's the thing about a scandal in the digital age. It's not just public, it's permanent. And for Christopher, his attempt to rehab his image was, frankly, embarrassing. He tried the whole humble journey approach, posed next to books about growth, did a podcast appearance where he talked about mental clarity and finding purpose through adversity, as if he'd survived a plane crash, not a self-inflicted legal mess. He never once mentioned the clients, not the companies who paid six figures for actual legal protection, only to find out their money was used to shield a drunk driver with a LinkedIn page that looked like it belonged to a finance bro NPC. And that, right there, is why people stayed mad. Because if you just owned it, really owned it, it might have been different. If Christopher had stood up and said, "I'm ashamed of what I did. I broke the trust of people I'll never meet, and I don't expect forgiveness," that would have been something. But no, he wanted redemption without responsibility, forgiveness without facts. That's why this story keeps getting told. Because it taps into something we all recognize, that deep, bone-level frustration with people who live in a world where consequences are optional, until someone with a robe and a gavel decides otherwise. So, let's bring this full circle. This wasn't just a courtroom takedown. It was a reminder that no matter how shiny the building, no matter how many plaques are on the wall, or how many powerful last names are behind the firm logo, nobody is too big to be held accountable. And sometimes, all it takes is a judge who actually reads a brief. So, tell me, where do you land on this? Should the entire firm have gone under? Should Christopher have faced harsher sentencing? Or do you think this was already more accountability than most people like him ever see? I want to hear your take. Drop in the comments and don't hold back. And if you're into stories like this, where justice doesn't wear kid gloves, where courtroom decorum gets ripped open by real-world consequences, and where privilege finally hits a wall, like the video, send it to someone who needs a little schadenfreude today and subscribe. Because believe me, this won't be the last time the elite learn the hard way that rules still exist.